May I please, Lordship?
Yes.
Lordship, I think to mention item number 12 and 13.
Yes.
Yeah, I need to receive the instruction.
Hmm.
So 3 weeks time will be granted.
Learned Additional Advocate General, Mr. Tim Song, praised that he may be given 3 weeks time.
3 weeks.
3 weeks time to receive instructions and to file the affidavit on behalf of the state respondents. Stop. Learned Senior Government Advocate, Mr. C.D. Jamir, appears for the petitioner in PIL 4 of 25, and Learned Senior Counsel, Mr. Takamasa, appears for the petitioner in PIL 2 of 2026, and have no objections. Stop. Accordingly, list after 3 weeks. Yes.
Lordship, I have a similar pair on item number 17. Lordship, here we have filed the affidavit, but it was we found rejected. So this matter may be listed after a week.
Rejected, okay, in the registry.
Yes, yes, yes.
Learned Additional Advocate General, Mr. M.T.M. Song, submits that the affidavit in opposition on behalf of the state respondents had been filed. However, it has been rejected due to some defects. And therefore, he prays that the matter may be listed after 1 week.
After 1 week.
List after 1 week as prayed for. Yes.
May I please, my lords?
Yes.
My lord, I beg to mention item number 31.
Hmm.
And for the respondent number 4 and my seniors and personal certificates today. So if this matter may be listed after 2 weeks.
Yes. Learned Counsel, Mr. I. Jam.
I'm laboring for respondent 5 to 9.
Hmm.
Which made them fix on the second week of May.
13th then. 13th. Learned Counsel, Mr. I. Jamir, appearing for the respondent number 4, submits that the leading counsel, Mr. T.B. Jamir, has some difficulties today and accordingly prays for listing the matter after 2 weeks. The learned senior counsel for the petitioner, Mr. T. Jamir, has no objections. Stop. Mr. Subati Jamir appears for respondent number 5 to 9. Stop. List on 13/5/2026.
There is an interim lordship that may be continued.
Okay, the interim order passed earlier shall continue till the next date. Yes.
May please, your lordships. Lordships from the supplementary list,
Hmm.
item 38 and 39.
Hmm.
Your lordship, so there is an urgency in these two rate appeals.
Hmm.
There is a limited departmental examination which is scheduled to be held from 6th May. So if this can be listed on the 29th as first item on the hearing listing. Item 37.
Item 38
Item
and
number 38 and
39.
38 and 38 and 39.
Learned Counsel, Mr. A. Zimomi, appearing for the petitioner, submits that there is some urgency in the instant petitions as the departmental exam.
Limited departmental exam, yes.
Exam is due to be held on
6th, on 29th. 29th. The exam is slated for the 6th.
Is slated for the 6th of May, and accordingly prays for listing the matter on 29th of April. Stop. Prayers allowed list on 29th as prayed for. 29th.
As first item in the hearing.
As
list.
first item in the hearing list.
Much obliged. Otherwise, I also like to mention items 32 and 33. Though this is in the hearing list, usually, the appeals are yet to be admitted. And my learned friend, Mr. Gupta, I don't see his presence here today, the learned prosecutor for the Enforcement Directorate. If the appeals may be admitted and then they will come up for hearing after that.
It's not yet admitted.
Not yet admitted.
Admitted. 32 and 33. Okay. Just give me the file.
32, 32.
Petitions. Delay is condoned.
Delays condoned.
I have discussed.
Big petition, huh?
Yes, Your Ladyship.
Notice given.
Yes,
Notice
notice
accepted.
already accepted by my learned friend Mr. Y.P. Gupta on behalf of the Enforcement Directorate. Party is already represented, Your Ladyship. Yes.
The instant appeal under section 26(1) of the Prevention of Money Laundering Act 2002 has been filed. 1 minute. No. Sorry. Against order dated 25/5/2022. No.
Adjudicating authority, PML.
They are coming against that order.
Yes.
Mm.
OC numbers and so, that's one.
Where do we find the
Your Ladyship,
dates? Page 4.
No, my lords, 1 minute only. Reason with hand. Your Ladyship, let it be passed, kept on hold for a time being.
Okay.
I'll get it.
Call after something. Bit there, yes.
With your lordship, I bet to mention hearing item number 30.
Yes.
Lordship, here this is a consensus prayer that I pray that this matter may be listed next week. On consensus
Item
prayer.
30. Learned Additional Advocate General, Ms. V. Shukri, prays for listing the matter next week.
33.
And she has stated that it is a consensus prayer of the parties. So list next week on 29th, no? 29 for us prayed for.
Much.
Please, Your Lordship,
Mm.
kindly allow me to move one unlisted item. I filed habeas corpus petition
Mm.
challenging the detention order, which expires on 18 May.
Mm.
I could not file prior to that because I could not raise some documents.
Mm.
So if
It's filed already.
yes, filed already 8 of 26 habeas corpus petition.
Okay, let's see. Give the mention. Mm.
Please, Your Lordships,
Yes.
I'd like to mention hearing item number 28 and 29.
Mm.
My senior Viash, who is leading this case, is indisposed, so please join us 3 weeks time, my lords.
Learned counsel appearing for the appellant submits that the leading counsel is indisposed and accordingly prays for listing the matter when
The 3 weeks. my lords.
after 3 weeks. Stop. Learned PP, Mr. K. Angami is present. So list after 3 weeks. Is prayed for. You're not pressing the bail application also?
My lord, here the accused is still not counted. Means he's not in jail.
Oh, okay. Then why you have filed a bail application then?
It's a criminal appeal.
Criminal
It's
appeal?
conviction and sentence.
Huh.
He's not in custody.
Yes.
He's not in custody.
Yes, correct.
He's on bail.
Yes.
Bail application
Then-
must have been disposed of.
Disposed of.
Is it disposed of? So we'll check.
Okay, okay. Let's see. Bail application. Just see the connected bail application 14 of 24.
I think it's against conviction on the book, so it's very unlikely that he's out of jail.
Ah,
I think it's in
Yeah.
custody. Probably.
hmm. You don't want to press the bail application today?
Yes, my senior is indisposed.
Okay, okay. Yes.
Public money.
The actual memos of appeals are the thinner bundles.
Oh,
Yes, those are the compilations.
this one.
Yes, yes. So the first one, 23(1) is in relation to the appellate guideline. Appellate guideline and
The criminal appeal 2. No, criminal appeal 2 is root.
criminal appeal 2 is root.
Yes.
Yes.
Yes, Albert, just come on. Criminal appeal 1, 15, 15. Not this, no. Yes.
And for lady to straight to the prayer, which begins on page 23. It begins on page 23 of the defendant appeal.
Yes.
And page 24.
Mm.
So the
Page
first,
23 and 24.
yes, 24 the prayer.
Yeah.
The first order I'm challenging is page
Okay,
24.
okay. The what did I say? The instant appeal. This is that item which we left out, no? The instant appeal under section 42 of the Prevention of Money Laundering Act has been filed against the order dated 29/10/2025, passed in FPA such and such. You just check from the cost tag, no? Passed by the Learned Appellate Tribunal under SAFEMA, New Delhi. Stop. Para. Heard Learned Counsel for the petitioner, Mr. Akito Zimomi. Stop. By filing the instant appeal, the petitioner has prayed for quashing and setting aside the provisional attachment order number 1/2021 dated 11/8/2021, the order dated 25/5/2022 passed by the adjudicating authority in O.C number 1522/2021, final order dated 29/10/2025 passed in FPA-PMLA-5248/GWH/2022, and also for a direction to the respondents to release from attachment the properties of the appellant attached by the provisional attachment order number 101/2021 dated 11/8/2021 and confirmed by the adjudicating authority by order dated 25/5/2022 in O.C number 1522/2021. Stop. It is submitted by the Learned Counsel for the petitioner that notices have already been accepted by Mr. Y.P. Gupta on behalf of the respondents number 1 and 2.
1, 2, 1 and 2.
Respondents number 1 and 2. Hence, no formal notice is called for. Stop. The appeal is admitted. Call for the records from the records will be from the
appellate tribunal,
the
address is at number 3, the performer is planning.
okay. Call for the records from the appellate tribunal under SAFEMA, Government of India, such and such performer respondent. Okay. So list after 4 weeks. The votes.
Who will represent respondent number 3?
Mr. Y.P. Gupta.
He is also.
Three also.
No, the Y3, but the respondent number 3 is just a proforma respondent. But actually not necessarily to be at a party of things.
Actually, it's 1 and 2.
One of them.
You have served extra copies also?
Yes,
Extra copies.
same order in the next.
Same order in that other criminal appeal 2 of 2026 also.
In your leadership in respect of items 3 to 9, the last order was that to identify the submit the report. Item 4. Fourth line.
4 and 9.
Yes. On the tracking report. The tracking report is available in addition.
Item 4.
Yeah. First of all, team service among the respondents 7 and 8.
Item 4.
Reports,
No.
tracking report. Too.
Item 4 to yes.
Item 4 to 9.
9. Yes.
Delivered.
In this number 8, it has shown as delivered. In respect of respondent number 7, there is no report as such in the issue. But both of them are from the same university.
Yes.
From the same university. They are officials of the same university.
This Daulat Singh. Daulat Singh is respondent number.
8.
Respondent number 8.
Number 8.
And then, okay, in respect of respondent 7, it is not showing.
But there is no report issuing.
There's no report. Can we team serve? Because both of them, they are serving the same university. This one has received, but this one does not report. Can we serve? Team serve? We can't serve. Since even if they are in the same university, we cannot assume that he has also received.
See, the respondent number 7 is a registrar of the university, and the respondent number 8 is a controller of examinations.
Should have. Postal tracking is not there with regard to.
This is the postal tracking.
It does not indicate anything.
For respondent number 8, yes.
Yeah.
For 8, it says.
Yes, but 7 it does not.
Registrar.
Sure.
Nothing.
So the controller of examination, he has accepted, he has received notice. But the registrar, there is no report.
There's no report. Can we seek a report again from the postal authority regarding this? This is the one they've submitted.
Yes.
So they'll probably not have anything else.
Very well, we can do that.
Maybe after some time, it may show also.
We can do that.
For 8, we'll say Jim
Yes.
serve.
Pointing out that it's the same address, so kindly cross check.
And the office note dated 19/1/2026 indicates that return service report on respondent 7 and 8 is awaited. However, today, when the matter is called, the learned counsel for the petitioner, Mr. A. Zimomi, has submitted the tracking report in respect of respondent number 8, wherein it shows that the item has been delivered. So accordingly, the notice on respondent number 8 is deemed served. Stop. However, in respect of respondent number 9, the report, respondent number 7, there is no report regarding delivery. So accordingly, the counsel for the petitioner shall obtain a tracking report and submit the same after 2 weeks.
After 2 weeks.
After 2 weeks. Stop. Least after 2 weeks. Learned Senior Government Advocate, Mr. N. Nangami, appears for the respondents
1 to 6.
1 to 6.
I'm obliged.
Yes.
Yeah, Mr. Lordship.
Hmm.
I'd like to mention item number 26 and 27. My senior is in bereavement. So if the matter will be set after 2 weeks.
Your senior bereavement. Okay. Learned Counsel, Miss, I forget your name, Yoka Kokla, submits that the leading counsel, Mr. Santiago, is in bereavement and accordingly prays for listing the matters after
2 weeks.
2 weeks. both 26 and 27, okay? After 2 weeks, yes,
May this,
prayer is allowed.
as per order of this Honorable Court,
Mm.
I've been endorsed with the court complaint. I've been endorsed by legal services authority to represent.
Okay,
the
okay,
complaint.
for the complainant,
Yes, respondent number 2 complainant.
okay,
So this.
yes. Learned Legal Aid Counsel, Mr. Tushio Longomer, has entered appearance, has been appointed as Legal Aid Counsel for the respondent number 2.
Two.
For the respondent number 2/informant. And the letter of appointment dated 8 April 2026 is kept on record. Okay.
My lady,
Yes.
if a copy of the bail
Okay,
application
okay.
as well as the.
The petitioner, the learned counsel for the appellant shall supply a copy of the appeal memo as well as the bail application on the learned legal aid counsel for the respondent number 2 during the course of the day. During the course of the day. Yes.
Senior
List
prayer
of the day.
item number 10.
Consent. Let me keep on record, huh? Same council. Yes, same order. 10 also. Item 10 also. Yes.
Yeah, this your lordship.
Mm.
Lordship, with the consent from the other opposite party, I beg to mention item 16 on behalf of the senior Madam
16.
Lordship, thinks my seniors in this post, if this matter can be fixed after 2 weeks.
Learned counsel, Mr. Such and Such, mentioning on behalf of Mr. Yangarwati, learned CGSC, submits that the learned CGSC is disposed today and accordingly prays for listing the matter after 2 weeks. So the learned counsel for the petitioner, Mr. Such and Such, present and has no objections. List after 2 weeks. Yes.
Lordship, similar prayer for item 19.
19. That also on behalf of Yangarwati.
Lordship.
Same 19, Yangarwati, but here is for the petitioner. Yes. And who's for the respondent in 19? Oh, same. Okay, okay. Yes. Yes, 19 also after 2 weeks.
Lordship,
Yes.
that's the place.
May it please, Your Lordship,
Hmm.
I beg to mention item number 36. On behalf of Ms. Livika, counsel, after 2 weeks. She's on maternity leave.
Okay. Learned Government Advocate Mr. Chila submits on behalf of the Government Advocate Ms. Livika, who's appearing in the matter, to list the matter after
3 weeks.
3 weeks, as the learned counsel is on leave. Stop. List after 3 weeks as prayed for. Petitioner, have you obtained the consent? None appears for the petitioner when the matter is gone. Yes.
One for the second.
You informed the petitioner?
Call motion, item number 1.
May I please, Your Lordship? Lordship, I am appearing on behalf of the petitioner. Your Lordship, instant matter pertains to my detention under National Security Act. And as such, I am assailing my detention order through this instant petition, Your Lordship. If, as per the prosecution story, that particular victim by the name Kyoto Jimomi was abducted by the members of NSCN Khango while he was returning his home. So as per the prosecution story, while he was returning in his car to his home, that undergone frictions. They have broken the car of glass of the car and accordingly forcefully taken him to their camp, that is at ceasefire office of Kango at Thiluku village, Dimapur. And accordingly, they are illegally those factions. They have confined him and tortured him, and accordingly he got injured. So in the meantime, some civil organizations they interrupted in the matter, and accordingly on the same day at midnight, he was released, but purportedly after signing a agreement where he was forcefully made to sign for paying rupees 30 lakhs as tax. So here, Lordship, accordingly, the victim's wife, she has lodged an FIR before the Difupar police station, and which has been registered by Difupar PS case number 4 of 2026 under section 142.3, 351, 308, 202 IPC, read with section 7 NSR. Accordingly, Your Lordship, during the course of this investigation, the IO of the case has prayed before the Honorable Court to also add some sections under UAPA. Accordingly, the Honorable Court has added that sections of UAPA. So, Your Lordship, while I was under detention, the Commissioner of Police and District Magistrate has passed a detention order under NSA, and accordingly, I was detained under NSA. Until now, I'm still under detention, Your Lordship. Your Lordship, after detention order, which was passed by the District Magistrate Dimapur, I made a representation for invoking a detention order. So while I was waiting for my consideration of my representation, in the meantime, the state respondent also to say detaining authority, that is respondent number 1, has approved my detention order, and I was directed to be detained under detention till 26/5/2026. So in the meantime, Your Lordship, the representation which I had submitted before the concerned authority, even my representation was rejected on the ground that there is no merit in my representation. And
Okay.
accordingly,
We will issue notice because there are only certain meters under which the detention can be challenged. So here, I think you are challenging it on the ground that the order of detention was not reported to the central government within 7 days, and that there was no mention in the detention order that you are under judicial custody.
yes, and Lordship, as well as whatever document I have received while I am under custody, and I have not received any document that my matter has also been referred to the advisory board for consideration of my detention. That is also one of the ground, Your Lordship.
Where is that? It is not there in your grounds.
Lordship, page 16. Page 16.
Clause C. Clause C.
Yes, Lordship. Yes, Lord.
Okay. Heard learned counsel for the petitioner, Mr. P. Surin. Stop. The case of the petitioner in this in the present application under Article 226 of the Constitution of India is that the petitioner has been detained under the National Security Act 1980 and by the detention order, by the impugned detention order dated 27/2/2026. Stop. The learned counsel for the petitioner has assailed the impugned detention order on the ground that the mandatory provision of Section 3, Clause 5 of the NSA 1980 has not been complied with by the detaining authority, as the detaining order has not been reported to the central government within a period of 7 days. Stop. It is also alleged that the mandatory provision of Section 10 of the NSA has not been complied with by the detaining authority, as the state government has not referred the detention order to the advisory board within a period of 3 weeks. Stop. Another ground which the petitioner has taken is that the detaining authority has not mentioned in the impugned detention order dated 27/2/2026 that the detainee was already in judicial custody in connection with the Pupar PS case number 4 of 2026. Stop. Issue notice, issue notice.
My lord, except for
Next week, can you produce the reports next week?
My lord, 2 weeks more.
2 weeks.
Lordship, I have a little prayer. My name is there in the Vaklatnama, but my name has not been reflected in the cause list. So I pray to the Honorable Court that the registry may be directed to reflect my name also.
Since that will be
In the-
done. Who accepts notice on behalf of the central government, Union of India? Okay. Note, what did I say? Issue notice returnable in 2 weeks. So the learned government advocate, Mr. Tipapom, accepted notice on behalf of respondent 2 and 3, and Mr. 1, 2, and 3, and Mr. Such and Such on behalf of Mr. Yangarwati for the respondent number 4. Yangarwati CGC for the respondent number 4. Stop. List the matter on 6th May. On which date the learned government advocate shall produce the records. Okay. And also file if so advised.
Yes.
So
As I prayed that registry may be directed to reflect my name in the cause list.
P. Suren as counsel for the petition.
Mazhar.
Obvious looks.
From the supplementary cost list, item number 34.
Please, notes.
The present public interest application is with regard to the All India Bar Examination, with regard to the examination center. Now, the All India Bar Examination is conducted by the BCI across the country, and now it has become a mandatory exam for the practice of law in India. Now, the first bar exam was conducted in 2010, and even after 15 years till today, the state of Nagaland does not have an examination center. And the last AIB examination was conducted on 30th of November 2025, and across 56 cities, there were 399 centers. And till that, the law students and the law graduates of Nagaland does not have the
Nearest center is Gauhati.
nearest center is in Gauhati. So the students have to travel hundreds and thousands of kilometers there with so much of expenses, accommodation problems, logistics, as well as sometimes even students from remote parts of Nagaland. We have heard
Assam has only one center, Gauhati.
Guwahati, there are few cities.
I
Assam
think
is
I think only
Only-
Gauhati.
Only
Assam.
one.
There's only one.
What about other notice?
Mizoram has one. Tripura has one. Meghalaya has one. And Manipur has also examination centers, except for the
Except Nagaland.
That's-
Okay. The instant public interest litigation has been filed seeking for a direction to allocate an examination center in the state of Nagaland for the purpose of enabling law students and law graduates in Nagaland to appear for the All India Bar Examination, under bracket you write AIBE, okay? All India Bar Examination, which is conducted by the Bar Council of India on a yearly basis since 2010. Stop. The petitioners are law graduates.
The petitioners are practicing advocates.
Practicing, okay. The petitioners herein are practicing advocates.
So meeting
Practicing
is a
advocates.
number.
The learned counsel for the petitioner, Mr. Tushi Olongomar, submits that despite conducting the AIBE exams in more than 56 different cities in 399 centers across India, there has never been an examination center in Nagaland. Stop. It is submitted that the state of Assam has an examination center at Gauhati, the state of Mizoram, Manipur, and Meghalaya also have,
Tripura also.
and Tripura also have examination centers in their own states. Stop. The petitioners therefore pray for a direction to the respondent number 2, to establish a permanent examination center for AIBE exams in the state of Nagaland, preferably in Kohima or Dimapur, before the next scheduled AIBE 2026, that is on 7/6/2026. Stop. The petitioners have also prayed for a direction to the respondent number 2 to include Nagaland in the list of examination centers for the purpose of all upcoming exams henceforth.
Worships, I've made an interim prayer. At least a temporary examination center.
We'll
to
see.
be
We'll see.
arranged.
The petitioner also prays for an interim direction pending disposal of the instant petition to direct the respondent authorities to designate a temporary examination center for the upcoming AIBE 2026 to be held on 7/6/2026. Stop. Para. Issue notice returnable in 4 weeks. Stop. The petitioner shall take steps for service on the respondent's number. All the respondents,
We have served copies to the Union of India.
the respondents 2 and 3. On the respondents 2 and 3,
Who's representing? Bar council, you have to.
they'll have to take
They have
steps.
to take steps.
Take steps on respond 2 and 3 by speed post as well as usual process. Stop. The CGC has accepted notice on behalf of respondent number 1 and learned additional advocate general, Mr. Im Tim Song, has appeared on behalf of the state of Nagaland respondent number 4. Stop. On the next returnable date, the interim prayer will be considered. An effort will be made.
Since I have just one,
Without hearing them, we
Yes.
cannot.
but on April 30, 2026 is the last day for submission of petitions. So before that, if the matter the interim prayer may be considered, if not today. So in this examination, the students of Nagaland can appear the exam here in the state. Because there are instances where they have missed the exam, because they are coming from remote places of Nagaland. And then sometimes they don't have any relatives or anyone to even assist them in Gauhati without knowing the place. And there are cases where, because since there's no avenues to give the exam, some law graduates, they have given up on the profession.
They will incur expenses in Gauhati.
Not just expenses, but then difficulties in
No,
Right.
that we understand.
Lot of expense.
But then the time constraint, because
Yes.
you're saying last date is
last date of registration is on April 30, 2026. And the
30th
exam is on
30th
27,
April,
2026.
30th
This is a tentative schedule.
Tentative schedule.
Oh, no.
How would you serve bar council authorities? By speed post?
By speed post weekends.
Speed post, it may take a week at least.
We can, if I can try explore the possibilities of serving by way of Dusty.
In that case, if you can serve by Dusty, maybe we can fix it on 29th. No,
Parallelly, they can.
29th is the next EB day. So on 29th, we can put it.
Just before the last date of submission.
For the interim prayer. Okay, you just say, instead of 1 month, you say, okay, you just leave that. And however, you just say, list the matter again on 29 for consideration of the interim prayer. And before the next date, the petitioner shall make efforts to serve notice on the respondent number 2 and 3 by usual process / speed post as well as Dusty. Okay. Yes. Based on 29th for consideration of interim prayer.
You kindly do a little bit of homework also in the meantime on this. That's suppose In case of a center, whether Kohima will be more comfortable, convenient or Dimapur?
For motion, item number 35.
May it please your lordships.
Yes.
Lordship, the petitioner here is the wife of the detainee. The petitioner has filed his present application selling the detention order passed against the detainee and the consequential orders.
This is also NSA.
Yes, your lordship, under NSA. The impugn order, detention order is.
Impugn order?
3 and if you find it. Detainee was arrested in connection to an FIR dated 17/12/2025. He was arrested on 12 December 2025. Thereafter, while he was in judicial custody, his detention order was passed against him.
What are the grounds you're taking?
Lordship, the grounds which I'm relying is that the detention order passed. The grounds of detention in the detention order passed are vague and irrelevant. There are violation of procedural safeguards and non-application of minor portion of the detention order and the grounds of detention, your lordship. After the detention order was passed against the detainee, your lordship, the detainee filed a representation dated 5/2/2026. But prior to that, the approval order was passed on 2nd February 2026. So that approval order was not given to the detainee, thus preventing him to make an effective representation. And that approval order was received only after he filed a representation. So I'm taking that ground also, your lordship.
By filing the instant application under Article 226 of the Constitution of India, praying for a writ of habeas corpus, the petitioner, who is the wife of the detainee, has assailed the impugned detention order dated 22/1/2026 on the following grounds. Number 1, that the grounds under which the detainee has been detained are baseless and irrelevant, and the grounds have been and the detention order has been mechanically passed without considering the propriety of exercising such extraordinary power, which curtails the rights of the detainee. So, the heard learned counsel for the petitioner, Mr. Zakato Chishi. Stop. It is also the case of the petitioner that the material facts on the basis of which the subjective satisfaction was derived for passing the order of detention ought to form part of the grounds of detention. Stop. However, in the instant case, the facts which led to the detaining authority to arrive at the subjective satisfaction for passing the impugned detention order are irrelevant and groundless. So, it is further submitted that the grounds of detention are vague and misconceived and based on irrelevant and unreliable materials. Stop. Where is that it was served to you, that it was not served to you, that the approval? Have you stated in your grounds?
Yes, your lordship.
Which one?
As mentioned in the petition, paragraph 4.
Ground number? It is also stated that the petitioner had also submitted a representation against his detention order, but the same has been rejected. Rejected, isn't it? But the same has been
Yes,
rejected.
rejected.
Being agreed, the petitioner is before this court. So issue notice returnable on 6th May 2026. So the learned government advocate, Mr. T. Bapom, accepted notice on behalf of the
Number one,
of the respondent number 1, 2, 3, and 4. And Mr. Union of India,
CGC,
have you
Learned-
served?
not yet, Your Lordship. In the course of that, they will serve, Your Lordship.
Oh, you have to serve.
They are present
The,
here.
the,
so-
the learned counsel for the petitioner shall take steps to serve notice on the respondent number 5 through the CGC during the course of the day. Stop. And on the next date, the learned government advocate shall also produce the records and also file affidavit if so advised, list on 6/5.
Much obliged.
Please, my lordship.
Yes.
I beg your pardon, my lord. Item number 36. It has been mentioned for 3 months, 3 weeks, I'm told. However, this is the first time it has been listed after filing this appeal way back before the Good Friday holidays. So at least, lordship, I pray that notice may be issued. This is the first time.
It's a writ appeal.
Writ appeal, lordship.
Let's see.
After filing, this is the first time it's coming up.
That means Libika must have accepted notice.
Must be. She appeared in the writ petition, but she is under maternity, so it
leave.
might take again another how many months that I don't know. Lordship. So
Can some other government advocate take over if it's going to be delayed? When is she returning from leave?
To save time.
we can say no.
There are so many of you on the panel.
Yes,
It can be entrusted to someone else.
my lord, and whom she will take up the matter. She will take up the matter.
She will take up the matter.
of course. But just for Lordship, I'm only on the issue. We have been granted skill pay. But here, if Lordship will kindly come to page 46 of the, it is confined to only with effect from this. The Honorable Court has granted skill pay with effect from the date when we approach this Honorable Court. So we are saying that at least
you want it from
from the day at least. Here the question is, we were appointed on a state post-creation payment in 2016. But that was not given to us, and instead we were given rupees 31,315 without giving us the post-creation payment. And later on, we discovered that we have been appointed in a post-creation payment by the state. So the first batch, there was previous writ petition. The first batch, that is 2016 batch, they approached this Honorable Court because their 31,315 was again reduced to 25,000 after merging all other central sponsored scheme into Samagra Shiksha. And the first batch salary was reduced to 25,000. So why the present petitioner did not approach along with the rest is that our salary was not reduced. That's why we did not approach the court. However, the learned single judge has opined that we are fence sitters, but we are not. So at least legally we have to get our salary from the date when we were appointed. However, Lordship, when this first batch was granted scale pay from 16/3/2022, they went to Supreme Court also, and the Supreme Court dismissed their appeal. They filed for review. Review was also dismissed. So at least we have approached this honorable court before the outcome of the Supreme Court. So at least we should also be extended the benefits along with the rest of the similarly situated teachers who approached the Honorable Supreme Court. And we did not approach because our salary was not reduced. However, the first batch salary was reduced to 25,000. So this Honorable Court, only within the purview of giving us the salary with effect from 16/3/2022, when the first batch got the post-creation payment. That is our only limited prayer in this repetition, Lordship. We will give.
That means you got the relief, but the court single judge said that around 7 years had passed
Yes.
before you came
Yes.
to the court. So there is a delay of 7 years on the part of writ petitioners in approaching the court, and therefore you were given only with effect from the date of filing the writ
Yes,
petition.
Lordship. So here,
Date of filing the petition.
then of filing the writ petition. So here, my humble prayer before this honorable court is that our salary was not reduced, and in matters of salary, in matters of salary from the date when we were denied our salary, every day is a cause of action. So it cannot be limited to when we approach the court. Lordship, it will come later on that, but that is my humble, simple prayer, limited prayer before this honorable court.
No, but those grounds were before the learned single judge also. After taking everything into consideration, the learned single judge has given this from the date of the writ petition, filing of the writ petition.
Yes, of course.
Yes.
That's why we are under challenge.
Okay. Yeah. We can admit it also. It can be admitted. Yes. The instant writ appeal has been preferred against the impugned judgment and order dated 27/2/2025, passed in WPC number 117 of 2025. Stop. Heard learned counsel for the appellant, Ms. Z. Zimomi. Stop. It is the case of the petitioner that the petitioners in WPC such and such had come before this court claiming their post-creation pay band of rupees 9,300 to 34,800 with great pay of rupees 4,200 per month, as has been given to their counterparts. Stop. The petitioner's case in the writ petition was that the petitioners are similarly situated as the appellants in writ appeal number 9 of 2020, who had been given the relief, is it? Who had
Yes.
given the relief and paid the post creation pay band. Stop. The learned single judge, after hearing the parties, allowed the writ petition and granted and directed the respondents to grant the benefit of payment of post-creation pay band of rupees 9,300 to 34,800 with great pay of rupees 4,200. However, it was directed that the actual payment of the set pay scale should be only with effect from the date of filing of the writ petition, i.e. 26/6/2025. Stop. The learned single judge also observed that 7 years had passed before the writ petitioners came before this court, and thus there is a delay of 7 years on the part of the writ petitioners in approaching the court with their claim for being paid the post-creation pay band. Although they were aware that they had been appointed on contractual basis on a fixed pay against posts which were created with a pay scale with grade pay. Stop. Being aggrieved, the appellant has come before this court. Stop. Para. The appeal is admitted. Stop. Learned Government Advocate Mr. Thipapom accepts notice on behalf of the state respondents.
My lord, I'm appearing on behalf of Livicom.
Okay. On behalf of Miss Livika, Learned Government Advocate. Stop. List after 3 weeks.
Lodge.
List after 3 weeks. You delete the earlier order, okay? List after 3 weeks.
Lodge.
For admission,
Issue notice, Lodge.
No, admitted. It is admitted.
item number 2.
This is Lordships.
Yes.
The last order was is on 18th of
18.3.
18/3/2026. And the NHITCL was directed to file an affidavit, which is mentioned in paragraph 2. Accordingly, the affidavit, compliance affidavit has been filed.
And to arrive at a permanent solution pertaining to a wrongful DPR is under process and upon the same being sufficient. Okay, so Executive Director NHIDCL was directed to file the affidavit, and Chief Engineer PWD
Yes.
National Highways also to file
Yes,
the
that is
affidavit.
also fine. That is also
Also
fine.
fine.
But I'm going, I was only referring to the first affidavit,
okay.
with regard to paragraph 2.
Affidavit.
The doctor can kindly peruse the affidavit, first affidavit so that filed by respondent number 6 and 7.
Yes, highways.
It's going on and on and on. With this one, not with this one.
Yes, Your Lordship, they kindly appreciate the fact that the road, the landslides and rockfall has become a recurring problem. So it was the decision of this honorable court that the NHITCL should come up with a permanent solution.
Yes.
So that recurring problems yearly is prevented. Accordingly, a direction was issued. Accordingly, the PPR is under preparation, it appears, and after the completion of the PPR, the NID to be issued, and then proper steps to be taken thereafter. That is one part. Second part is that with regard to package 3, paragraph 6 of the affidavit of the
Paragraph
and undertaking has been given that it will be completed works except the RCC box tunnel project. The other work to be completed by 31st of May 2026. That was the assurance given last time on the last occasion. Accordingly, a direction was given to file a compliance affidavit. So that order will be recorded. So that will be recorded by this in the court.
Okay. By 31/5. And slope
31/5,
protection works
6, and for slope protection works by 24. And RCC box tunnel project to be completed by 2027.
Filed on 7th April.
Page
Paragraph
3.
Page 3.
Page, the relevant paragraph is paragraph 3 and 6.
Okay, this slope protection works by 24. So 24 is already over. Is it done?
One of the
Where's, yes,
should let us know.
come in front. You have stated at paragraph 6 that the slope protection works will be completed by 2026. So that is completed.
Ma'am, they have completed and they
Ah.
have submitted proposal for issuance of completed certificate also.
Okay.
So that will be recorded now.
Sure. And completion certificate is going to be issued.
They have submitted.
They have submitted. Okay. Okay, then bridge works will be completed by 31/5.
Yes.
31/5,
And RCC box tunnel to be completed by June
June
2027.
2027.
And my lady, can't you refer to paragraph 3?
Paragraph 3, yes.
That is preparation of flood protection, that is, DPR is under preparation.
Mm.
And we are expecting that the final DPR to be submitted by 30/6/2026.
2026.
So we would like to know from the initiative CLRC when the DPR will be finalized the NIT issue thereafter. So some information is required from the initiatives on this issue.
If you submit the final DPR by 36,
Yes.
after that, the
Then,
steps to be
then-
taken for within how much time? You'll.
They have submitted draft data. We have examined it once also, and now they are submitting again. We had told him to incorporate some changes. Then they will submit final DPR by 30 June. And then after that, ma'am, we will send it to ministry for approval.
So approximate timeline
Yes,
uh,
for approval.
for approval and then issuance of NIT.
On the instruction on the next day,
You get the instructions on the next day regarding the timeline, okay?
Approximate time.
Approximate timeline. And NIT. Okay.
now
So
complete with the
then,
affidavit filed by the government. State government, the state portal from Totsuma bypass.
6 and 7.
Yes. Now, your ladyship, the lordship, may kindly go to paragraph, page 5, paragraph. Yeah, page 3,
Page 3.
I'm starting from page 2, paragraph 2.
This is this. Page 2, paragraph 2.
Yes, in conclusion, the compliance filed by the answering including with respect of one-time improvement of energy demand from KH 172 Totsuma bypass to 185, dairy will come falling under P220 division. And then compliance with the order dated 4/2/2026 and 8/3/2026 passed by this local.
Wait. When was the affidavit filed?
Was filed on the second April.
Affidavit of respondent number 5.
2nd April.
Respondent number 5.
2nd April. Filed on 2nd April. This is the one.
Second April.
Okay, paragraph 2.
Yes.
That in continuation.
The continuation of the affidavit of compliance filed by the answering deponent. Deponent in respect of one-time improvement of NH39 from Chenit 172 to 125, falling under P220 division 1 Kohima and compliance with the order dated 4/2/26 and 8/3/26 passed by this local court. Hence, the compliance affidavit answering deponent indicating the weekly wise progress status report would schedule physical and cumulative physical progress with effect from 5/2/26 to 25/3/26. And allow me to refer from A, from 5/2/26 to 11/2/26, physical progress was 11.92 and cumulative 1956. Then the next week it is 9/2/26 and 28/82. Then C from 9/2/26 to 25/2/26, 6.53 and physical progress is 35.35. Then 26, there's a total reduction. Physical progress is 0.13.
0.13.
Then from 5/3/26, it is 1.13. In fact, your lordship mechanism from A, if you see the physical progress, it is gradually going.
I think the engineer should come here and explain.
Now, your lordship mechanism, see the first one, the 1/4/26 to 7/4.
26.
Second page.
1/4/26. Okay. Yes.
Physical progress nil. First physical progress, the top.
Yes, yes.
Then the next one. The next one also, your lordship mechanism, the next one. That is 8/4/84. It is also nil progress. No work. So
2 weeks. 2 weeks, there's no work.
2 weeks, no work. And then the lordship mechanism will progress. Last few months. It has gradually reduced. After Hornbill Festival, everything.
It is reduced.
Everything stopped. That is one aspect. Secondly, your lordship may kindly allow me to refer to the affidavit of that paragraph 4, page 5. That the page 5, paragraph 4. That out of the total stretch of 12,464 kilometers in Chinage 172.92, Chotsumai bypass 184,540, 7 kilometers of bituminous concrete carpeting has been completed on 31/3/2026. The weekly progress status report from 1/4/26 onwards will be filed. This completion of carpeting on 31/3/2026. Lordship started from Nerike. Only on day before yesterday, I traveled the whole stretch. There are multiple potholes already. Though they are claiming that the carpeting was completed on 31/3/2026. Now it is only April. Only day before yesterday, in fact, I was inquiring from my learned friend whether he has also traveled that area, and he has agreed with me there are potholes. Big potholes where small vehicle cannot maneuver. So the quality of the work apparently is extremely poor because in the question of 2 weeks, if multiple potholes develop in the carpeting, then what will happen after 1 month?
That's very unfortunate.
So that also has to be looked into very seriously, and the direction should be given to repair all the potholes and submit a progress report. In fact, it is a fit case where the chief engineer may be called directly to appear and explain why there is zero progress.
In para 3, they are saying that due to scarcity of bitumen in the market,
Lordship,
the bituminous concrete works have drastically
very
slowed down.
interestingly,
So,
very interestingly, on the last occasion, the reason given why there is a scarcity of bitumen was because of the Gulf War.
yes.
That was the excuse given. That because of the Gulf War, they are not able to get the bitumen. That very day, unfortunately, the executive director in NHITCL was also personally present. This honorable court inquired from him whether they have any problem with bitumen.
Then he said no problem.
No problem. Your leadership will remember. So, non-availability of bitumen, whatever, because this carpeting has to be done from December. From this December onward, we are traveling that road. And before Hornbill, this work order was issued. So for 2-3 months, the whole winter, when it was dry, you were sleeping. When the rain started, he started constructing because Lordship, rain will be a very good excuse. So that must have been the reason why he waited for rain to come so that he gave an excuse that they are not able to complete this work or that work. So non-availability of bitumen since November or first week of December cannot be the excuse.
What is most important is that the approach should be very honest.
Lordship, that is the issue.
No, of course, honestly, they have said zero progress for 2 weeks.
He can't skip because he cannot skip the reality because every day, ordinarily, Lordship, all your Lordships are traveling that route every day, so he can't skip.
Lordship, here, as per that weekly progression, the physical progress is going down since last few weeks. Lordship, here, we all know that there was a bad weather and the condition of soil is such, it's very weak. And now, especially in the dumping area, our part is only for bituminous carpeting now. So when there is a rain, it is not possible at all. So, and at the same time, as I stated earlier, that because of the Iran war, the bitumen is available, but it's very costly. So, for which department is facing problem to acquire bitumen from the market. And plus, the weather, since till now there is a weather is uncertain here. So down there, our main focus is bituminal carpeting now. So that's one of the factor. And apart from the risk pothole, though, at least time to time we have to go for the repairing and maintenance.
No, that has to be done because you have stated in your affidavit that it's just completed.
Yes. Only
Carpeting has been completed as on today.
Only 5 kilometers left. Actually, that is the first other way we went for the marketing. Carpeting bituminous. Then we left only 5 point something kilometers left. But now, because of the weather and because of the condition of the soil, now the problem has dropped up again.
Logic that
Even on the completed portion.
subject to repetition. Logic, certain portion has been completed by 31st of March, and which requires immediate delay. That expects volumes of the seriousness and quality of the work. The most important aspect is now it is a recurring problem last so many years. Several direction has been given. Now state government is not able to manage. If the state government is not able to manage, why not hand over the load to some other agency who will do quality work? That is also an issue to be answered by government.
Let the engineer appear and explain on the next occasion.
Lordship.
Yes. Heard Learned Senior Counsel, Mr. Takamasa.
With assistance would be helpful.
Yes, that's why we can ask him, no? Senior Counsel, who appears as amicus curiae in the proceeding, assisted by Mr. Santilong. Stop also heard Mr. Im Tim Song, Learned Additional AG for respondents number 3, 4, and 5. Mr. N. Mozui for respondent number 15. Mr. Moa Jamir for respondent number 6 and 7. Mr. N. Longkamer for respondent number 20. Who else is there? And Mr. T.B. Jamir for respondent number 19. Stop. In pursuance to the order of this court passed on 18/3/2026, the respondent number 6 and 7, as well as the respondent number 5, have filed their compliance affidavits. Stop. The same has been perused. Stop. Para. The affidavit of the respondent numbers 6 and 7 states that the detailed project report, DPR, for the existing Dimapur to Kohima road is presently under preparation for slope protection measures along the entire stretch falling under packages 1, 2, and 3. And that the DPR consultant will submit the final DPR by 30/6/2026. So it is also stated that with regard to package 3, which has a total length of 14.21 kilometers, consisting of 3 distinct projects, namely road works and bridge works, RCC box tunnel project and slope protection works. It is stated that the road works, including bridge works project, are likely to be completed by 31/5/2026, slope protection works by 24/2026, and RCC box tunnel project by June 2027. The learned, who came just now on behalf of NHTCL? The managing projects, your name, Mr. Such and such, take it. Okay. Appears for the, on behalf of the NHIDCL and has submitted that the slope protection works have already been completed and it has been, the documents have been submitted for issuance of completion certificate. And the same will be issued by how much time? 1 month? 2 weeks?
Before issuance or completion certificate, there are some procedures like one independent person from outside comes and check itself, and they also verify.
Okay. Anyway, it is completed, so the same will be issued within a month. Within a month from today.
After verification. After necessary verification.
After necessary verification. After necessary verification. Stop. The project manager,
Yes.
engineer projects has also submitted that the bridge works will be completed by 31/5/2026 and the RCC box tunnel project by June 2027. On the issue of the detailed project report for the existing Dimapur Kohima road for the entire stretch under packages 1, 2, and 3 for slope protection, he has stated that the same has been sent to the he has said that after the final DPR is submitted, the same will be sent to the Ministry of Road Transport and Highways, and thereafter the NIT will be issued for the same. It is therefore directed that on the next date fix, the respondents 6 and 7 shall file an affidavit regarding the showing the completion certificate of the slope protection works, and shall also file an affidavit regarding the progress of the bridge work project, which is stated to be completed by 31/5/2026.
Carpeting of package 3 lot.
Yes.
Carpeting of
as well as the carpeting of package 3. The respondents 6 and 7 shall also, by the said affidavit, state the approximate timelines by which the approval from the Ministry of Road Transport and Highways shall be obtained, and also the timelines for issuance of the NIT. The respondent number 5 / Chief Engineer PWD National Highways Nagaland Kohima, by filing his compliance affidavit, has shown the weekly progress with effect from 5/2/2026 to 25/3/2026. It has been pointed out by the learned amicus curiae that the work progress has been decreasing
Physical.
that the physical progress has been decreasing, and finally, in the week starting from 26/3/2026 to 31/3/2026, the physical progress is 0. So, also in the latest weekly progress report for the week 1/4/2026 to 7/4/2026, the scheduled physical progress is 0. As well as in the week starting from 8/4/2026 to 14/4/2026. Stop. The learned amicus has also pointed out that in the affidavit of the respondent 5, it has been stated that the total stretch, out of the total stretch of 12.64 kilometers, i.e. chainage kilometer 172.900 to Jotsama bypass, and then in bracket Jotsama bypass, close bracket, to 185.540 kilometers under bracket Leary Welcome Gate, 7 kilometers of bituminous concrete carpeting has been completed as on today. Stop. However, in reality, the several potholes have been noticed on the said stretch of road, even last week.
Yes.
Even last week. Stop. It is therefore directed that on the next date, the chief engineer, PWD, National Highway, Nagaland, shall appear before this court in person and explain as to how the physical progress has been nil, under bracket 0%, for the past, how many weeks? 3 weeks. For the past 3 weeks. For the past 3 weeks. For the past 3 weeks. And also explain
The poor quality.
Explain the poor quality of the bituminous carpeting on the stretch on the stretch of road from Jotsama bypass to Leary Welcome Gate.
Yes.
To Leary Welcome Gate. Stop. That's all.
Yes.
List on.
Since the first is the last.
Yes.
So maybe we come in the early part of June.
We will list after that. 3rd of June
Yes,
is
Lord.
list on 3/6.
For admission, item number 3.
So many.
The order dated 25/3, your leadership.
25/3.
Yes. And paragraph 12 of we give a final opportunity to the respondent who wants to place instruction before his court as regards the outcome of the notice inviting tender dated 8/12/24. As well as what further actions have been taken for the purpose of converting the immediate land in 2-lane in National Highway 329A.
Okay. This is regarding that Menamsi.
Yes.
Menamsi Pibla. Give a final opportunity to the respondent 1 to place instructions before this court as regards the outcome of the notice inviting. Yes, any instructions?
May I please, your lordship?
Yes.
Lordship, we have received an instruction recently. So if this can be placed before the Honorable Court next week by our senior.
So let it be by-
Instructions regarding the NIT.
Sincere apologies, Lordship.
Let it be by
Problem
way
is-
of an affidavit.
No,
Instructions
the
can be
instructions
properly-
have to be filed by way of affidavit, not just placed like that before the court.
Instructions.
Okay,
Affidavit.
by next week, can you file?
They give them 2 weeks, right?
Yes, I think next week you won't be able to file. 2 weeks, okay, and you file it.
Lordship.
It's 2 weeks,
Uh-uh.
Wednesday, then.
Yes, Learned Councillor Mr. A.Z. Momi is present for the petitioner. Mr. Masile Zorote, Learned Counsel, appears on behalf of Mr. Yangarwati, Learned CGSC. Mr. L.T. Sanctum, Learned Additional Advocate General, is present on behalf of Respondent 2, 3, 4, and 5, and Mr. Moa Jamir on behalf of Respondent number 6 and 7. Stop. By the order dated 25/3/2026, this court had given a final opportunity to the respondent number 1 to place instructions before this court regarding the outcome of the notice inviting tender dated 8/12/2024, as well as the further actions which has been taken for the purpose of converting the intermediate land to 2-lane in NH 329A, capital A. Okay, stop. Learned Counsel Mr. Masilezo Rote submits on behalf of Mr. Yangarwati CGSC that certain instructions have been received from the respondent number 1, and he therefore prays for 2 weeks' time to place the same by way of an affidavit, to place the same before the court by way of affidavit. Stop. The prayer is allowed list the matter after 2 weeks, and before which date the respondent 1 shall file the affidavit and supply copies of the same to all the parties. Yes. List.
Why didn't we also be reflected as hearing?
Oh, okay, Mr. Joshua Sheki for respondent number 8. Okay. List after 2 weeks.
For admission, item number 11.
May it please your lordship. My lord, today I was unable to appear before your lordships because of the ongoing bar election. May I pray this matter be taken up on 13th of May instead, my lord,
Okay.
for admission hearing.
There is an IA also. What is the IA for?
That was for delay condonation. Both of them are to be heard together, my lord.
Okay. No, the delay has to be condoned first, no?
Yes, my lord may condone it and we place it.
We have to issue notice on.
We have to issue notice on the delay, and then none appears for the respondent also.
No, the delay, they have appeared, they have filed the written objection.
Oh, they have filed their objections.
And it was agreed that
Okay.
the matter would be heard. Yes, the matter would be heard together, my lord.
Okay.
That was the consensus.
Okay. Mr. N. Barua? Mr. N. Barua appears for the applicant. Stop. Learned Counsel, Mr. C.D. Rongsum appears for your
Yes, my lord.
respondents.
Lordship, one number 1.
Appears for the respondent number 1. Stop. Mr. Barua prays that the matter may be listed on when? When do you want it?
13th May.
13 May. He has gone offline.
13th of May, my lord.
On. No.
13 May, 1-3,
13th May.
On 13 May.
1-3.
For hearing on the IA number 83 of 2025. Okay. Yes, 13. Praise allowed list on 13 May. Yes.
For admission, item number 14.
Piece of law, during the referendum, the dated 17 March 2026, past interpretation number 31 of 2026. In viewing judgment and orders in phase number 52,
Hmm.
The matter pertains to naming of undisputed pending bills.
Pending bills.
Yes, and this writ petition was dismissed solely on the ground of delay matters.
Hmm.
My ground before there's a lot of orders for admit liability, the delay latest does not apply because there's a continuing law. This from the day the completion certificate was issued and the liability was admitted.
Hmm.
The course of
But
action has
15
no-
years.
Years, right?
Hmm. And you were also given liberty to approach the civil court.
But when the bonus liability is already admitted by the respondent authorities.
It's admitted.
Yes, yes,
Or they had admitted.
they have admitted.
Oh. Submitted the evidence.
If your lordships may kindly come to page number 43.
Okay. Since we're very, yes, this is- Okay, the instant appeal, instant writ appeal, has been presented against the judgment and order dated 17/3/2026, passed by the learned single judge in WPC number 31 of 2026. Stop. Correct, learned counsel for the appellant, Mr. Moh Jamir. Stop. The case of the petitioner is that by filing the WPC 31 of 2026, the petitioner had come before this court seeking a direction to the respondent authorities to pay a sum of rupees 37 lakhs 17,200, which was the pending bills due to the petitioner for a contract work for maintenance of the Dimapur Ganesh Nagar Road in the year 2010. He had stated that the work was completed on 9/11/2010 and that the same had not been paid to him. Stop. The representations have been submitted by the petitioner, but his grievances were not redressed, and therefore he had come before this court. He had come before the single bench. He had come before the writ court. Just say.
Sorry for
He had come before. Yes.
There are two work orders. The first one is amounting to rupees 37. There's another work order.
Oh, chicha.
Page number 4, para 1.
One was 37 lakhs 17,200.
Yes.
And where is that?
Page number 4, paragraph 1.4.
No, but in the judgment, is it reflected in the judgment? Because in the judgment, it only talks about this 37 lakhs. Okay. Just say, and another work order had been issued to the petitioner for improvement of town road at Dimapur, opposite to the bank colony Dimapur, and this work was also completed on 27/9/2011 for an amount of
20 lakhs.
rupees 20 lakhs. Where is that? 20 lakhs 20,700. Stop. So both are not paid.
Both are not. And both are admitted.
It was the case of the petitioner that both these pending bills were admitted liabilities by the state respondents. Stop. However, the said writ petition WPC 31 of 2026 was dismissed by the learned single judge on the ground that the petitioner had approached the court after a delay of 15 years, and therefore the court was not inclined to entertain the writ petition. Stop. Being aggrieved, the petitioner has preferred this writ appeal. Stop. The appeal is admitted for hearing. Stop. Learned, who accepts notice? Learned additional AG, Mr. Im Tim Song, appears for the state respondents. So list after 2 weeks, 2 weeks?
2 weeks.
List after 2 weeks.
For others, item number 15.
May please, Lord. Lordship, may kindly see the office note dated 17 April 2026.
Records are missing.
My lord,
How can that be? The trial court records.
that I don't know.
What to do? The registry says that it was handed over to Mr. K. Angami.
Worship, that registry, the same issue was in court to me also. So I perfected the KM company, that whether there is a LSR or not. He was not part of the, as per the record is taken by the KM company like that. But it is not.
Was taken by
KM company.
K. Angami.
As per the record of
The registry.
registry. But when I contacted KM company, that it is no more with him, that record. So I think it will take some more time to trace it out.
Because the registry has contacted the court concerned also.
Yes.
And then they said that it has already been sent in 2019 and it has not returned back.
And initially,
No, it must be lying somewhere in your office.
initially it was time,
Them sometime.
also.
You look.
Yeah, so
you look for it because
time to trace it out.
because we cannot reconstruct also such things.
Yes.
It is not possible.
Not possible.
Learned counsel for the appellant, Mr. Shiprizo is present, as well as Mr. Im Song, additional AG for the state no, this is criminal appeal.
Criminal appeal.
PP, not PP, appearing as PP in this present case. Stop. The office note dated 17/4/2026 indicates that the trial court records of GR 30/2016 was handed over to Mr. K. Angami, learned PP, in the year 2022. Stop. However, upon inquiry from the learned PP, he had informed that this case is now handed over to Mr. Im Song, the learned advocate, additional advocate general Nagaland. Stop. Today, the learned advocate general, additional advocate general submits that he needs some time to trace out. He needs some time to trace out the records from the office, as it is not in his custody at present. Stop. It may be stated that the office of the Principal District and Session Judge Kohima had also informed the registry that the records of the GR case 30/2016 had been transmitted to the registry of Gauhati High Court Kohima bench way back in 2019 and has not returned. Stop. Therefore, the learned additional advocate general Nagaland shall make efforts to trace out the records from the office of the advocate general Nagaland. Stop. List the same after 3 weeks.
3 weeks.
The 3 weeks. Otherwise, it's all ready. No paper book is all there.
There are
certain documents.
paper book, which are very minor.
Yes.
Yes. Mark.
For others, item number 18.
Lordships, this note indicates that respondent, notice upon respondent number 5, the MPAC is yet to be effective. In fact, last 4 occasions, they are not appearing in.
They don't have a standing
Yes,
counsel.
we don't have a standing counsel. In fact,
Hmm.
before the learned single bench also, only after Dusty they started appearing.
Oh,
So my respectful submission, we have waited for 4 times.
then you
The
take
fifth-
steps by Dusty
Yes.
what to do.
Yes.
Learned senior counsel for the appellant, Mr. Takamasa is present. Stop. The office note dated 23/3/2026 indicates that service report in respect of respondent number 5 is still awaited. Stop. Learned senior counsel submits that they have already, that the petitioner has already, that the appellant has already taken steps on the respondent number 5. How many times? 3 times. Twice.
This is the
Twice.
fifth occasion the matter is come.
Okay, on 4 occasions, on 4 occasions,
Last 4 occasions,
no, wait. But steps taken,
only once.
only once.
To register that.
That steps had been taken, on 5/2/2026, 5/2/2026. Stop. It is submitted that even in the, even during the proceedings of the writ petition, the respondent number 5 appeared before this court only after service through Dusty.
Yes.
Through Dusty. Stop. Therefore, the learned counsel, senior counsel prays that he may be permitted to take steps on respondent number 5 by Dusty mode. Stop. The prayer is allowed. Learned senior counsel shall take steps by Dusty on the respondent number 5 and thereafter file the compliance affidavit.
After we kindly list it, after 2 weeks, a date may be given.
List after 2 weeks will be 6th May.
Lordship.
List on 6th May.
For orders, item numbers 20 and 21.
May I please, Lordship?
Hmm.
My lord, I have taken step and I have served the copy to the respondent.
Hmm.
He was present.
It's for delay.
Delay.
Yes, my lord, here, IA 36/2026 is for delay of 839 days.
Hmm. Learned Government Advocate Mr. Tibapom is present and submits that he has taken steps for notice upon the respondents. How did you take steps?
I serve personally.
Oh, served.
Yes, and then more.
Personally.
Lordship, here for the delay, we don't have any objection regarding that. Delay may become
that he has taken steps for notice on the respondents by serving the same on the council, Mr. Mojamir.
Yes, ma'am.
Mr. Mojamir. So, Mr. Solo, M. Solo, Learned Counsel, appears on behalf of the respondents and submits that he has no objections regarding the present application. So, the instant application has been filed under Section 5 of the Limitation Act, praying for condonation of delay of 839 days in filing the connected writ appeal number 7 of 2026. So, the reasons for the delay
I've explained in para 2, 3, and 4.
have been set out in paragraphs 2, 3, and 4 of the application herein. Stop. We have gone through the reasons for the delay and find that sufficient force has been shown. And moreover, the respondents also have not objected to the prayer for condonation. Stop. In the result, the instant application is allowed. Stop. The delay of 839 days in filing the writ appeal number 7 of 2026 is condoned. The application is allowed.
My lord, IA number 37 is
Then-
stable. My lord, my humble submission is for the interest of justice, this able to be admitted and fixed for hearing, my lord.
What was the direction?
My lord, here in the direction was issued to the respondent to consider the petitioner case as per to pay the salary as per ROB 2017, whereas the petitioner is already enjoying ROB 1993. And the ROB.
Where is the impugned judgment?
Page number 11, annexure 1. In my state, IA number 37.
No, we'll first see the read appeal memo. In your appeal memo.
Appeal memo.
Page 59.
Page 86 to 80, page 86. Annexure 4. It is the
to see the case of the petitioning person. Page 59.
Page 86.
Page 86.
Yes, my lord. In my appeal memo, my lord. 97, page 9.
WP 153. WP 153 of 22.
Page number.
Page number 97. Thank you. My relevant question for 97. 97. That is relevant paragraph 97.
Yeah, 22.
97.
Yes, paragraph 22 and 23.
Super and contingency.
I'm agree for paragraph 22 and 23.
Direction was to pay him the salary of scale of pay of sweeper as per ROP 2017.
Yes.
Whereas he is receiving
93 ROB. Because their service has not been regular as well. And the ROB 2017 is only for the regular employees. ROB 2017 is.
But they have been, he has been directed to be paid the regular schedule.
Yes, my lord. Yes.
The principle of equal pay.
Yes, my lord. Yes. And my lord, this ROB 2017 is.
and it appears that single bench has relied on a division bench order.
No,
Similar.
That's that scale. He has been asked to pay the
Scale of pay
which is 2017.
which is 2017.
The court, the learned single judge was on the equality of the pay rather than regular, not
Not whether he's
between regular
not whether he's a regular or contingency, but the similar nature of work.
Yes, ma'am.
So they were directed to do it.
Yes, ma'am. And my lord, the respondent has been given direction to pay as per 2017. And this ROP 17 is applicable only to regular employees.
No, but what about this other case, State of Nagaland versus Hishini Sumi, which has been referred?
Yes.
There also similar order had been passed.
Regarding the for the stay, your lordship, if objection can be given to file an objection, your lordship. For the hearing.
Okay. In the main case, you say the instant writ appeal has been preferred against the judgment and order dated 13/10/2023 passed by the learned single judge in WPC number 153 of 2022. So, heard learned government advocate Mr. T. Papom for the appellants. Stop. The case of the appellant is that the petitioner/respondent had filed WPC 153 of 2022 praying for a direction to the respondents/appellants to grant him the scale of pay on the basis of ROP 2017 in line with the principle of equal pay for equal work. Stop. The learned single judge by judgment and order dated 13/10/2023 allowed the writ petition and issued a direction to the appellant/respondents to consider the case of the petitioner to consider the case of the petitioner and to pay him a scale of pay similar to that of a regularly appointed sweeper as per ROP 2017 within a period of 3 months from the date of the judgment. Stop. The appellants herein have stated that the petitioner/respondent being a contingency, is it?
Yes, Lord.
Being a contingency employee is receiving a scale of pay under the 1993 ROP, and that only regular employees are entitled to receive a scale of pay as per the ROP 2017. Stop. Being aggrieved by the directions passed in WPC 153 of 2022, the appellant is before this court. Stop. Let's admitted for the The appeal is admitted. Stop. List after 1 month or 2 weeks. List after 2 weeks. Stop. The interim prayer shall be considered on the next date, and the interim prayer is kept open for consideration, and the respondent is also at liberty to file his objections. It's advised.
What's all that?
For orders, item numbers 22 and 23.
Please, Lordship.
Yes.
Lordship, on CA 41, CA 41 is a condemnation for delay. This appeal has been preferred against a common judgment dated 19/11/2025, passed by the Honorable Single Judge.
We'll issue notice on the IA.
Okay. There is a delay of 76 days.
Okay. Whatever it is, we have to hear the other side also. No? On the IA, okay, IA 41. The present IA under Section 5 of the Limitation Act has been filed, praying for condonation of delay of 76 days in filing the connected writ appeal 10 of 2026 against the common order dated 19/11/2025, passed by the learned single judge in WPC number 264 and 263 of 2023. Learned Counsel, Learned Additional Advocate General, Mr. Im Tim Song. Stop.
Lordship, here I'm engaged.
Okay.
Yes, Counsel.
Okay. Not as government advocate. Okay, Learned Counsel. Okay, for the applicant, Mr. Im Tim Song. Stop. Don't say Additional Advocate General. Huh? Stop. Issue notice returnable in 4 weeks. So the learned counsel shall take steps for notice on the respondents number 1, 2, and 3 by speed post as well as usual process within 3 working days. Is up to process.
For orders, item numbers 24 and 25.
May I please your lordships? Lordship, in the IA, these were served on the respondents as early as 25/3/2026. there's a delay of 72 days in filing the appeal. And delay, I have explained in paragraph 3 and 4.
Your Lordship, here I am.
You're hearing,
Your Lordship, as for the, for delay, Your Lordship, there's no objection.
okay, then we will condone.
Yes.
In the IA, no? IA 44 of 2026, you say the instant application under Section 5 of the Limitation Act has been filed by the appellant, praying for condonation of delay of 72 days in preferring the connected writ appeal number 11 of 2026. Stop. The heard learned senior counsel, Mr. Takamasa, for the applicant. Stop. The reasons for the delay has been set out in paragraphs 3 and 4 of the application. Stop. We have perused the same and find that sufficient cause has been shown by the applicant for the delay of 72 days in filing the writ appeal. So, the learned counsel for the respondents, Mr. M. Solo, has also not raised any objections regarding the delay. Stop. In the result, we are of the view that the applicant has been able to explain the reasons for the delay of 72 days, and therefore the same is condoned and the application is allowed.
With regards to the same petition, the new order judgment is at page 23 and enter 1. In fact, your Lordship, your Ladyship will be very well aware of this case.
Acha.
It was the FCI case. Lordship, it was the very single bench has partly allowed the writ petition. Accordingly, a writ appeal was filed by the other side also. And initially, Lordship will remember it was heard before Honorable Justice Michael and your Ladyship, and thereafter, Lordship may kindly see the order by which the writ petition was withdrawn by the other side because it was partly allowed. Then, Lordship may kindly see the prayer of the writ petition. In the other writ petition, the prayer also I have annexed, just to get an idea about the case.
Refunding them.
Yes.
Refund. Modify the judgment award if it's to refund the total amount of such and such with interest at 9%. Yes.
Now, Lordship may kindly allow me to come to page 29, the operative paragraphs. From paragraph 11, page 29. As per the facts noted above, the impugned action of recovery is connected with MIT dated 24/1/2019, in which the petitioner had submitted its plea and was accepted. It, however, appears that due to certain reasons, the petitioner had withdrawn from the process and prayed for refund of the security deposit. This court, by order dated 22/11/2019, passed in C-2/26/19, has directed for consideration of such representation. It is noted that there was no memorandums as such to refunds, and the matter was left to the discretion of the corporation. It, however, appears that representation was considered. Thereafter, the security deposit was refunded. In continuation of the NIT dated 24/1/2019, further action was taken against the petitioner by order dated 7/1/2020, whereby the petitioner was blacklisted for 5 years and EMD was directed to be forfeited. The said action was unsuccessfully challenged by the petitioner in WPC 75/2020, which was also upheld by the division bench of this court, and subsequently the SLP prepared by the petitioner was also withdrawn by order dated 26/8/2022. Though the writ petition was dismissed, the subject matter which appears from the order is the immune action of declaring the participation of the petitioner in the future work for 5 years in forfeiture of EMD by order dated 7/1/2022. The present action has emanated from a decision of the corporation on 16/7/2021 to assist the loss for the MIT dated 24/1/2019, which might have been incurred by the corporation. It also appears that such decision has been taken in a legal opinion by the counsel of the responding corporation, accordingly by communication dated 22/7/2021. One, an amount of 40 lakhs, 27,369 was directed to be recovered for greedy reference. The breakup of the amount to be recovered is exacted here and below. Lordship, you can see the breakup because here lies the defects. Factual, with due respect, the learner single judge discrepancies in the factual assessment. I'm coming to that. That's why I put like expenditure incurred in
Application of foreign IDs, such.
No.
Expenditure incurred in.
If you have no objection to stay, no problem.
The Lordship here, have consultation. Your Lordship here, the council, leading council is from Manipur, Your Lordship. And since there is some situation there, Your Lordship is not able to appear through either VC or physical. So humble prayer that matter can be listed on either last week of May or June, Your Lordship. So that situation that time would maybe much better.
No problem for that, but the issue is this. They have other issue of contempt notice to me for non-compliance. So if unless until the case is admitted, interim is granted, then I'll be cooperation will be in difficulty only for that purpose. Otherwise, we will go for expeditious disposal. So then you allow me to read, and if the Lordship is done satisfied, issue an interim and we go for expeditious disposal. I am also for early disposal. But then, just to highlight for
maybe they have objections regarding the admission. Is it?
But because of the situation here in Manipur, Your Lordship.
But then
No communication can be met.
He cannot appear online also.
No, Your Lordship.
because
Oh, network is.
also the notice was issued on 25/3. So sufficient time has been granted. So Lordship, for the ends of justice, unless there is an interim order. On the one hand, they are expressing difficulty. On the other hand, they have issued a contempt notice to me for non-compliance of the check. So can you allow me to refer? So if this court is satisfied, then the interim order will be issued and we go for immediate disposal. I am also for immediate disposal. In fact, I was thinking that if the counsel is here, we can dispose of the case today itself. Now, expenditure incurred for foreign license is 3,20,533. Then expenditure incurred in the filing of WCC 2 lakh something. Data of official engaged in legal proceeding 15,000. Second penalty 4,59,000. Security deposit refunded 36,27. Altogether 40,27,369. Lordship, in the interim order, by this judgment, Lordship, then Lordship kindly take note of the security refunded 30 lakhs.
Security deposit.
30 lakhs,
30 lakhs,
61,000.
60,000.
Pursuant to the aforesaid decision, the corporation has issued 2 communications to the UCO Bank on 5/8/2021 and 6/8/2021 for encashing 2 amounts, namely 10 lakh 54, 14, 97. That is the 30 lakhs issue. A mere perusal of the aforesaid communication dated 5/8/2021 and 6/8/2021 would reveal that such bank guarantees were made by the petitioner in connection with certain other works. Though the learned accounting counsel can be correct in completing that the aspect of the implication of bank guarantees the prerogative of the corporation. Such prerogative can be exercised only in connection with the work in which such bank guarantees were submitted. In the instant case, it however appears the decision to encash is in connection with some other works. Further, well, there may not be absolute bar for recovery. It does appear that any manner of notice or show cause was given to the petitioner before Indian recovery was made. At this stage, Mr. Ao, counsel for FCI, has drawn attention to the following communication dated 9/8/2021 given by the UP banks to the petitioner. This court has, however, noted that such communication is on the aspect of invocation of the bank guarantee and cannot be deemed to be given an opportunity before such invocation. In any case, a bank guarantee is in the form of escrow account where the bank is to act as per direction of the corporation. With regard to subject matter of 75, this court is of the firm opinion that subject matter in the said petition, which was dismissed, is wholly different from the subject matter of the present case. This court is also has also considered the laws relied upon by the learned counsel. 17 is operative paragraph. In view of discussion in the case laws which have been relied upon, this court is of the opinion that the immune action of engaging the bank guarantees by communication it is 5/8/2021 and 6/8/2021 is sustainable and low, and is accordingly set aside. It is however made clear that the present inference is only with aspect of the violation of principle of natural justice. If at all, the cooperation is to make any recovery, it has to be done strictly by following the process of law by giving adequate opportunity to the petitioner to make such representation. Such action has to be supported by properly worked out calculation as to how the amount of 40 lakh 2769 has been arrived at. In other words, the process has to be fair and transparent, which is hallmark of Article 14. Consequently, it is directed that the amount of bank guarantees which are subject matter of communication dated 6/5/8/2021 and 6/8/21 are to be refunded to the petitioner within a period of 45 days from today. Lordship, may you kindly allow me to see the prayer of the writ petition, so that because it was only partially allowed. Page 93 is the prayer.
Page
93 is the prayer of the writ petition. Imbued letter dated 16/7/2021. Then imbued letter dated 22/7/2021. Then
Impugn order.
so as many as 6 orders. Lordship, may kindly allow me from page 164. Page 164 onward is the imbued orders. Now, Lordship, quickly at 164 on 16/7/2021, a proposal was given for a recovery since the legal officer has given a proposal on 16/7/21 for recovery. The losses incurred by the FCI for non-performance of the contract. This is challenge. Then, Lordship, kindly see the next page, 165, the type copy at 166. This is the proposal, how much to be recovered. Expenditure, then Lordship, security deposit refunded for. This is the second order challenge. Then 167, if the decision of this of the competent authority type copy is from 168. So by 3/8/2021, it was decided that the amount of 40 lakhs will be recovered. Then Lordship, at page 171 is the notice issued to the bank by the competent authority for recovery of the first. Lordship, may kindly see the amount, 10,54,000. That is the first.
Where is that? Oh, first para.
Yes.
10,54,200.
Yes. Then second one, Lordship, may kindly see at page 173. It is 14,97,500. First bracket.
14,97,500.
These two notices, prior to in pursuance to the order dated, Lordship, prior to the in pursuance to the order dated 3/8/2021 at page 167. These two notices was issued for recovery of the two BGs, bank guarantees, amounting to 30 lakhs. Then, Lordship, 175 is the invocation notice to the petitioner respondent by the bank, which is not challenge. Then Lordship, may kindly allow me thereafter, he submitted a representation, which is at page 182, to the Grievances Redressal Committee against the actions of the respondent authorities. Against the first 3 imbued orders, he submitted a representation to the Grievance Redressal Committee on 7/8/2023.
Request for refunding.
At perusal of the whole representation, there is not a whisper about principle of natural justice. That notice was not given to me, was not taken because in the contract agreement, he is very much aware. Lordship, I will come to the contract because in the contract agreement, it talks about recovery of damages and set-off. Then, Lordship, 187, page 187, the competent appellate authority, the Provincial Refusal Forum, has rejected his representation on 23/4/2024, page 200, after considering all the aspects.
Page 200.
Starting from 187, but the lordship will find the date at page 200. This is the order of the grievance redressal forum by which his representation was considered
And rejected.
and rejected. Now all this, now in the writ petition, all this what he made a prayer for to set aside all these orders. What has happened is, lordship, the learned single judge, under alleged violation of principle of natural justice, only the documents at page 171 and 173, the rupees to the bank for recovery of the 2 BTs for amounting to 30 lakhs. Not the whole 44 lakhs Dr. Mechanic has received for that. Only partly. It relates to only 2 BTs.
The 10 lakh something and then 14 lakh something.
Yes. So only this was. The learned single judge has interfered with only these 2 notice. The learned single judge did not interfere with the order, the decision.
None of the other orders.
In fact, that is the passive orders. Dr. Gandhi appreciated that notice was issued on prior to the order of 3/8/2021, by which a decision was taken for recovery at page 167. Thereafter, again, then notices were issued. He submitted a representation to the grievance redressal forum. The grievance redressal forum has rejected his prayer. So, lordship, where is the question?
So this rejection order is also challenged,
but not interfered.
But not interfered.
Not interfered. Learned single judge has interfered on the 2 notices only on the ground of principle of natural justice. Now the issue is this. So I only satisfy the principle of natural justice. Lordship is well aware that the constitutional bench decision in Manika Kaddi, post-decisional hearing is upheld. In that case, passport was cancelled, and she approached the court on the ground of violation of principle of natural justice. The learned attorney general gave a concession that we admit, so we allow her to submit the representation. And in view of the submission of the representation, the case was closed. And gross principle of post-decisional hearing was appealed for the first time. Here, lordship, after the 3 impugn orders were issued, it is inbuilt provision is there to file an appeal before the grievance redressal forum. He filed. Principle of natural justice was not a ground taken. In fact, in the writ petition, in the grounds of appeal, violation of principle of natural justice was not a ground. And it was rejected. Then a single judge had not interfered with the decision of the main or basic order and the rejection of his representation. So, lordship, where is the question of violation of principle of natural justice? Secondly, lordship, the single judge has, by issuing an order, lordship is only the 2 notifications relating to 30 lakhs was interfered with, but then he is giving a direction. Lordship may see paragraph 17, the last 2 lines. He is giving a direction to revisit the whole amount of 40 lakh 27. Last 2 lines on page 17, page 32.
Page
32.
32.
The Indian judgment. From last 2 lines and such supported the proper work of which how the amount of. Now when he had interfered, when the learned single judge has interfered with only 2 pitches amounting to 30 lakhs, he is giving a direction to properly reassess the whole liability. So my respectful submission, Lord.
So what is that division bench judgment? I saw another division bench judgment.
Yes, your lordship, what has happened is, lordship, can you allow me? I'm submitting that this petition is squarely covered by a principle of constructive res judicata. Lordship, can you allow me that? Lordship, can you allow me to see my notes? Lordship,
Writ appeal 165.
138. Lordship, can you allow me to come to page 138? Now, after he was debarred for 5 years, like after he was blacklisted for 5 years, he he submitted a representation to the grievances redressal forum. Now, Manoj, what has happened is this honorable court in the early round of litigation gave a direction that he will submit a representation, then the representation should be considered for refund. Now the representation was submitted to the FCI Dimapur, General Manager Dimapur, and without sanctioning, without any approval from the higher authority, he had illegally refunded the amount. Accordingly, a disciplinary punishment was imposed against the hearing officials. And against the blacklisting of the petitioner for 5 years, he filed a representation before the appellate authority at page 138. Now, Lordship, here, while dealing with the issue, Lordship, you kindly allow me to come to page 146. Clause 12B. This order of 1/5/2020 was challenged in the earlier division bench. In the event of termination of this contract, 146, Lordship.
Page
In
146.
the event of termination of this contract, or in the event of any of the breach of terms and condition of this contract by the contractor, the general manager shall have the right to forfeit the entire or part of the amount security deposits of the contractor, or to appropriate the security deposit or any part thereof in towards the satisfaction of any sum to be claimed for damages, losses, charges, expenses, or costs that may be suffered or incurred by the corporation. From the above cited terms and conditions of the contract, non-deposit of the bank guarantee within the prescribed time, failure to carry out his obligation after his offer was accepted and communicated to him, the security deposit ought to have been released to safeguard the interests of the corporation. Therefore, the GRC, although finds the action of the GM Region 5 order dated 7/1/2020 to debar the party from participating in any future tenders of the corporation for a period of 5 years, absolutely in order in as per terms and conditions of the contract clause, but allowing the release of a security deposit with terminating the contract is shared on the obligation of mine on the part of the GM, which lacks bona fide intention. Part later dated 23/4/2019 requested the GM to extend a possible time as per MTF to enable him to submit his leases. His request for extension was accepted. 5 letter dated such and such with a levy penalty of rupees 2,44,000 in terms of clause 9B. Again, partly after depositing the amount of penalty of 2,44,000, second extension dated such and such for depositing requisite bank guarantee, which was allowed by the GM region with a levy of additional penalty of 4,89,000. Therefore, the plea taken by the contractor to his representation dated for his failure to deposit the BG to the recovery of receiving several treat from various unknown miscreants, thereby threatening him not to execute the said work, plus not carry any further loss. Further interim orders, then Lordship, 6.5 asked by the GM decision, while letter dated hereby when refund of the security deposit to the party concerned is following have been observed, then Lordship, a direction was given for refund, recovery again. So Lordship, pursuant to this order of 1/5/2020, we acted upon. Now Lordship may kindly appreciate the fact that this letter of 1/5/2020 was subject matter in the PC75, 149, page 149. His prayer was rejected. Then before the division bench
149.
and before the Supreme Court, Lordship, this was 176 is the writ appeal, which was dismissed. Then Lordship, thereafter in 181, he filed before SLB before Supreme Court and he had withdrawn. So Lordship, on the question of recovery of 4 lakhs, I'm making a ground that the reserved petition was totally barred by principle of constructive restitution. Because Lordship is well aware that
that's why I was asking you about the writ appeal, because it appears to be on the same same facts.
Lordship, in Chief Chandra versus Lieutenant Governor 2014-11 SCC, not only to what is actually adjudicated or determined in a case, but every other matter which the parties might and ought to have litigated or which was incidental to or essentially connected with the subject matter of litigation. That is constructive res judicata. My lord, you have already served a complaint notice to me. So my respectful submission, let the appeal be.
Okay, till the next date, we will stay till the next date and let them come and. The present writ appeal has been preferred by the appellants against the impugned judgment and order dated 4/12/2025, passed in WPC 231/2024 by the learned single judge. Stop. Learned senior counsel for the appellant, Mr. Takamasa, assisted by Mr. Santilo. Stop. The learned counsel for the learned senior counsel for the appellant at the outset submits that the subject matters in WPC 75 of 2020, writ appeal 165 of 2021, and the WPC 231 of 2024 are all interconnected and arising out of the same cause of action. And as such, the judgments in the earlier round of litigations also have a direct bearing in the present case. In fact, he submits that in fact the principles of constructive res judicata shall strictly cover the issue involved in WPC 231 of 2024. Stop. It is further contended that the alleged violation of principles of natural justice was never a ground taken in the writ petition nor before the grievance redressal. What is C? Grievance redressal.
Uplift.
Grievance GRC. What does it stand for? Grievance redressal forum. Just say grievance redressal committee. Stop. Even otherwise, no prior notice was required before invocation of the bank guarantees, as it is within the corporation's prerogative.
And parts of the contract agreement.
And was part of the contract agreement. Stop. The appellants contend that there was no illegality in the action/decision-making process of the FCI. Stop. The appellant further contends that the petitioner in the writ petition number such and such had assailed several orders. Where was that? The prayer of the petitioner? Page 93.
Page 93, 94.
Had assailed several orders which were the basis, isn't it?
Yes.
Which were the basis of recovery. Stop. However, the learned single judge has not interfered with any of the orders.
Basic orders.
Any of the basic orders. Stop. Para. Issue
The petitioner also filed a writ appeal for modification of the judgment, and that was withdrawn. So that's how the immune basic orders, which has
writ appeal 5, no?
Yes.
It is also brought to the It is also brought to the notice of this court that the petitioner/respondent had also filed a writ appeal, being writ appeal 5 of 2026 against the impugned judgment dated 4/12/2025 in WPC 231 of 2024. However, he withdrew the same, isn't it?
Yes.
However, the writ appeal was withdrawn and disposed of on withdrawal on 11/3/2026. Stop. The appeal is admitted for hearing. Stop. Learned counsel, Mr. M. Solo appears on behalf of the respondent and prays for time as the senior counsel, is it?
Yes.
As the senior counsel is from Manipur and cannot appear today as the due to the situation, due to the troubled situation in the state. And he also cannot appear through VC as the internet restrictions have also been imposed in the state of Manipur. Stop. List on
Worship on 3rd of June, Your Honor.
list on 3rd of June 2026 till the next for hearing till the next returnable date. The impugned judgment and order dated 4/12/2025 passed in WPC 231 of 2024 shall remain suspended. Yes.
For orders from the supplementary cost list, item number 37.
How many more items? Oh, yeah. Only that one, na?
Worship is an appeal against the judgment dated 16/3/2023 passed by the special court POSCO, Dimapur. Worship, paperwork is ready. Just may come up for the final hearing.
And respondents who's
Yes.
okay.
All are present.
Okay.
Worship, I'd like to get so must humble some reason at this.
When do you want?
I want that matter will be listed next to the top of the list, Your Worship, because otherwise it's not possible to come personally.
You can appear online also.
Online, some difficulties because it's not comfortable
Yes.
during the hearing stage, Your Worship.
Yes.
I don't know.
One day, we can fix it at 2.
Yes.
Will it be?
Letter is ready.
But no, not 2, I mean, not today.
On the next
On
date.
the next day.
On the next date.
Yes,
Top of the list at 2 o'clock.
yes, Lordship. Most.
So that you can stay that day and
Yes,
then.
We have to stay one day.
Yes.
Yes. Possible. Yes.
Certainly
On
possible.
29th, Your Lordship, next week.
Heard. Maybe, Mr. J. Khalid, learned counsel for the appellant, learned public prosecutor, as Ms. Madam S. Mary, and Toshi Long, counsel for respondable, legal aid counsel, respond number 2. The original TCR has already been received and paper book has also been prepared. The learned counsel submit that the matter is ready for hearing. In this context, Mr. Khalid, learned counsel, submits that which date you prefer?
29 next week, Your Lordship.
The matter may be
Next
fixed
29th.
on 29th and preferably on the top of the list or at 2 p.m. The learned counsels for the other side do not object to the said. Accordingly, list the appeal for hearing on 29/4/2026. We'll keep it open or 2 p.m. We can keep it open.
We'll keep it on.
Okay, we can informally do it. It may be possible in the early part also. Sometimes
Yes.
depends on the matter.
Unlisted motion, item number 40.
NSA.
My lord, the petitioner is detained.
PNDPS.
Yes.
PNDPS.
Detained under PNDPS. So the detention order is at page 45, annexure 3.
Page 45.
Not first page. And my lord, confirmation order I've annexed in page 58, annexure 8. It's
D8.
detention was confirmed and extended up to 18 May 2026.
58.
Page 58, Annexure 8, my lord.
Okay.
Here, my lord, the
Yes, just take us to the grounds.
the ground is non-application of mine, as the detainee is already under judicial
In custody.
custody, and he have not moved bail for 157 days. But the detaining authority have taken bail.
Commercial quantity.
Yes, my lord. Yes, and this is his first case. He's a first-time offender. My lord. Yes.
The petitioner herein is aggrieved by the impugned detention order dated 17 November 2025 and the impugned confirmation order dated 18 February 2026. Stop. Third, learned counsel for the petitioner, Mr. Baklin Chapu. Stop. The petitioner herein submits the impugned detention order and the confirmation order is that the detainee was already in judicial custody when the detention order dated 17/11/2025 was issued, and he had not even moved bail application seeking his release, and therefore there was no likelihood of the detainee being released on bail. However, the same was not reflected, was not reflected in the detention order, and therefore there is a total lack of application of mind on the part of the respondent authorities / detaining authority. Stop. Another ground which the petitioner has taken is that the detainee is a first-time offender, and there was no likelihood that he would indulge in prejudicial activities in the future. Stop. Then what are the other grounds?
The other ground is that the detaining authority has not stated that he have to make representation. Yes.
The detaining authority also did not inform the detainee that he had a right to make a representation against the detention order. Stop. Para. Issue notice returnable by 6 May 2026. Stop. The learned government advocate, Mr. Tiba Pom, accepts notice on behalf of the state respondents.
1, 2, and 3.
1, 2, and 3. Union?
The CCC is absent. We beg the proceeding.
The learned counsel for the petitioner shall take steps for service on the respondent number 4 through the learned CGC within 3 days.
Yes, ma'am.
Within 3 days from today. Stop. On the next date fixed, the learned counsel for the state respondent shall also produce the case records and also file affidavit if so advised. Stop. List on 6/5.
Much obliged.
PROCEED. Ah, teman, stop. Ini sampai muncul dia juga.